Weapons laws. What are they? Can you carry a gun? Can you not? When you get in criminal trouble whenever you have a weapon in Texas? Hi, I'm Jeff Hampton with the Fulgham Law Firm. I want to thank you for joining us here today. Today, I want to try to give you the ultimate guide to weapons crimes in Texas, okay? And by the way, if you wait around to the end of this video, I'll also give you a free ebook, What to Do If You Have Been Charged with a Crime in Texas. Okay, so let's do a breakdown real quick of weapons laws in Texas. Who can carry a handgun under the new Texas law? Remember, there was the Firearm Carry Act of 2021 that was recently enacted and became effective in September 1st of 2021. So one of the things we can do is in order to carry a handgun in open carry, okay, that was the open carry law that went into effect. Number one, to qualify without a license to carry openly, you must meet the following requirements. You must be 21 years of age or older. You must not have been convicted of one of the following crimes: deadly conduct, assault bodily injury, terroristic threat, or disorderly conduct, discharging a firearm or displaying a firearm. And you must not be prohibited from possessing or carrying a firearm under federal law, and you must not be prohibited from possessing a firearm in a public place under Texas law. Those are some of the prerequisites, all right? Now, here's the thing. It was enacted, the Firearm Carry Act of 2021 was enacted, and it defines what is a handgun. First, a handgun refers to any firearm that is designed, made, or adapted to be fired with one hand. And under Texas law, you only have two methods of carrying a handgun. This is important. It must be concealed with no part of the weapon showing, or openly in a holster, okay? Now, what if you do not keep the gun holstered while you open carry? If you do not leave the handgun holstered, you could potentially, there is still the prospect of facing a possible criminal charge of unlawful carrying of a weapon. And the only exception to this rule is if you had a justifiable defense under Texas Penal Code Chapter 9, all right? Now, here's where we get into trouble. I've laid out the basic framework of open carry. The problem is open carrying can easily turn into a deadly conduct case. This is the part I want you to understand. This happens all the time. Good people, no prior criminal history, they end up getting arrested for deadly conduct. One of the riskiest things you can do is when you open carry is, think about it this way, someone else can become offended at your open carrying, not like what you're doing, and now they claim they are alarmed, quote unquote. Generally, under Texas criminal law, you cannot display a gun in public in a manner that is designed to alarm another. Many people refer to this as brandishing a weapon. Now, under Texas criminal law, if someone intentionally or knowingly displays a firearm or deadly weapon in a public place in a manner calculated to alarm, you could be charged with either disorderly conduct or deadly conduct. Now, this is confusing part of the law because it's very subjective about whether someone is alarmed or not. Some people are alarmed at the sight of any gun or any weapon, and they're going to get very upset about that, and they'll exaggerate what they think they saw, which could lead to a disorderly conduct or a deadly conduct charge. And one example of that, State versus Ross provided some clarity in 2019. There was case law that came out on this that states to be guilty of disorderly conduct under Texas Penal Code Section 42.01A8, a person must intentionally and knowingly display a firearm in a public place in a manner that he knows is likely, under an objective standard of reasonableness, to frighten the average ordinary person. Now, I like this law, okay? Here's why. Previously, it was subjective. Now it says it must be an objective standard of reasonableness. Now we go from the subjective, meaning your opinion, versus what is objectively reasonable, okay? And so as a result of that, your criminal defense attorney needs to know about that case. That is something that's very important, because I'm going to tell you, many prosecutors don't know about that case either. And it's fairly recent law. That's very important. So it doesn't really matter what the so-called victim thought about you. What matters is what is objectively reasonable under the standards, okay? Now, how do I comply with the Texas holster requirements under the current Texas law? So previously, an openly carried handgun by a license holder required the gun to be carried in a shoulder or belt holster, okay? Now, this is no longer required. Under Texas law, handguns carried openly by license holders and those carrying in public under the authority of the law are only required to use a holster which can be simply a holster worn on your person or the use of a vehicle holster like a magnetic dash holster. Okay? Now, what happens if you're carrying a gun and you're intoxicated? This is where it gets a little sketchy. You're going to have problems if you do this, okay? Nobody intends to do this. People forget they got the gun in the car. People forget they're carrying the gun, right? And I've seen people forget they're doing it and they walk into a bar, and that's a big problem, okay? They end up getting arrested for a felony, all right? But here's the deal. Under Texas law, if you are openly or concealed carrying a gun and you are intoxicated, you are going to be charged with a Class A misdemeanor of unlawful carrying of a weapon. And that is punishable by up to a year in county jail and up to a $4,000 fine. Now, can you possess a firearm in a public place under Texas law? Yes, and we've talked about that. You can possess a firearm in a public place in Texas, but the problem is if you've previously been convicted of a felony, you cannot, right? If you're a previous convicted felon, you'll be prohibited and maybe not even convicted. What if you were placed on a deferred probation for an assault family violence offense or any family violence designated offense? That will be a prohibition of you possessing, purchasing, or owning a firearm in any way because of that conviction or deferred adjudication. So one of the other things is you cannot just bring that anywhere you want either. There are certain limitations that you have on you. I can't bring a gun into an airport. It's a prohibited place. I can't bring a gun into a bar. I can't bring a gun into a school. These are prohibited places that you are not permitted to take a weapon to. And there are also something called prohibited weapons. You're not permitted to own machine guns, short barrel firearms, armor-piercing ammunition, explosive weapons, firearms, silencers. It is prohibited by Texas law and federal law to possess those as well. Now, I've already identified that under the Firearm Carry Act of 2021, prohibited places are mentioned under the Texas Penal Code 46.03 that you cannot take weapons into certain places. And I could give you a list of them. Schools, polling places, courts, racetracks, amusement parks. Yeah, most of these things people know. You just can't bring a gun there, okay? Now, here's the thing though. Here's the change. The Firearm Carry Act of 2021 also says if a private property owner posts a no firearm, now you need to be on the look for this if you carry a weapon, okay? If there is a publicly posted no firearm sign as mentioned in the Texas Penal Code, section 30.05, if you enter the premises with a firearm without a license, you could receive a criminal trespass charge, okay? You could actually get in trouble for that. You could potentially get arrested. Now, let me identify very quickly. I'm trying to move as quick as I can here to talk to you about the crime of unlawful carrying of a weapon. Here's the thing. Under the Texas Penal Code, section 46.01, weapons, I've already given you a long list of them. Certain ones are prohibited. You're not to possess certain weapons. Certain knives, certain zip guns, firearm silencers, shotguns with barrels less than 18 inches long. But section 46.02 goes a little bit deeper into this. It also talks about that a person commits the crime of unlawful carrying of a weapon if the person intentionally, knowingly, or recklessly carries on or about his person a handgun at the time of the offense, is younger than 21 years of age, or has been convicted of a felony or committed in a 5-year period preceding the date that the offense was committed, and is not on the person's own premises or premises under the person's control, or inside of or directly en route to a motor vehicle. Now, here's what I want to be clear about that. So and I don't want to get into this too much here, but there are certain rules that if you've even been convicted for a felony before, after a 5-year period, you may still be able to own or possess a firearm for your safety at your home. You can't carry it around, but you can actually have it at home. But you got to get past that 5-year period, okay? That's really important. Most people don't know that, but there is an opportunity for you to still be able to have a weapon after that 5-year period, okay? Now, I'm not going to get into a lot of these other ones, but it's really important. If you are not permitted, if you are a convicted felon or you're prohibited by law from possessing a firearm, you could face an unlawful possession of a firearm by a felon. That is a 3rd-degree felony, punishable by up to 10 years in prison and up to a $10,000 fine. So it's very important you know your rights if you're permitted to possess a firearm or not, okay? Now, what happens if you are charged with a weapons law violation? Well, according to the Criminal Procedure Code, the magistrate will release the weapon to the owner. Here's what's important. If your case is dismissed, you may, and I get this question all the time, I'm innocent, I didn't do anything wrong, I want my gun back. Well, let me just be real clear about this. It is discretionary by the judge. So it may be possible. Now, I read the code to say that the judge shall give it back. But I'm going to tell you, a lot of these judges up here have a hard time with doing that, and it can be a real battle to get your weapon back, okay? So I bring that up to let you know there are opportunities where your attorney can make the request to have that weapon returned, but it's never going to be returned unless your case is dismissed because it is seen as evidence, okay? Now, finally, here are a few of the defenses. What if you lacked criminal intent? First thing I want you to know is you must have had the intent to carry this weapon on or about your person. What if you did not know that you had a weapon in your possession? What if the carrying of the weapon was merely a mistake or an accident? We have represented multiple clients in many situations where they took a gun to an airport. Now, look, it was obviously an accident. Now, you can't act intentionally, knowingly, or recklessly, but we had a client who took a gun to an airport. They had been to a gun range practicing, and they had been to that gun range 3 months prior, and they only used the bag 3 months later to go to the airport, and they totally forgot that the gun was in there. Well, obviously that was a mistake. It was negligence. We argued that it was not intentional, knowingly, or reckless, and we were able to make that presentation to a grand jury to help them understand that there was no crime that was committed here. I always joke about this, but back in the 90s, former Dallas Cowboys coach Barry Switzer did the same thing. I think he was on his way to a game in Buffalo or something, and he just happened to have his pistol in his carry-on. And guess what they did? You think they took good old Barry to jail? No, they did not. They let Barry go on to the game, right? But if it's good enough for Barry, it's good enough for you. Our argument is if Barry made a mistake and it was an accident, then clearly only an idiot or someone who's going to bring, someone who's a terrorist is going to bring a gun into an airport. That is not something anybody would intentionally, knowingly, or in most times recklessly do, okay? So the other thing is, I say that to say this, that it's not always clean cut and just, dry that you did or didn't do this. Even if you had a gun in your vehicle, your spouse or a family member may have had that weapon in there. You having knowledge of that weapon and exercising care, custody, or control over that weapon is critical. The same elements of possession for drug cases apply to gun cases. They have to prove that you intentionally or knowingly exercised that care, custody, or control in order for the state of Texas to prove the case beyond a reasonable doubt. So listen, finally, what if you're facing a deadly conduct charge because of a weapon? Listen, if you're facing that deadly conduct charge, you need to have an attorney really get to the bottom of this, because it may very well be that the display of the weapon was not objectively alarming, and that case can be presented to a grand jury for argument that it should be thrown out. Now listen, I've given you a lot of different options here. I want to encourage you to go to my website. You can look it up at the Fulgham Law Firm. We've got a lot of this information that's documented on our website. And I want to encourage you to visit some other videos that talk more about Texas weapons law. And I want to thank you. Listen, I promised you a free ebook if you waited around to the end of this video. I want to encourage you to click through down to the bottom and fill in your information. We'll send you over the ebook, What to Do If You've Been Charged with a Crime in Texas. And if you are facing a weapons charge in the North Texas area, don't hesitate to contact the Fulgham Law Firm at this number above that's been on the screen the entire time I've been talking. Contact us. We'll be happy to give you a free case analysis and a consultation and answer your questions and see what we can do to help you. All right, I want to thank you again for joining us. We'll see you on our next video series.